You don't have to come and confess. We're looking for you. We gon' find you. We gon' find you. So you can run and tell that. Run and tell that. Run and tell that. Homeboy, homeboy.
Hello everyone, welcome in this video. We're going to be discussing trial being delayed due to the state appealing for their evidence back after the judge's decision. Now, the judge's decision, as far as I'm aware, is still currently a sealed document as far as this case goes. So I will be refraining from being too detailed or descriptive about the judge's decision, despite it still being posted publicly online, because it is hard to tell what the status of anything is with it remaining public after being told it's sealed and all kinds of things. So with that being said, we will err on the side of caution and we will cover what I know to be a non-sealed document, the state's statement of issues to the Supreme Court. This will be very legally dense and a lot to go over, so I'll jump right into these documents. So this is filed in the Supreme Court of the state of New Mexico, the statement of issues. Number 1, whether the district court erred when it suppressed all statements made by defendant in the presence of law enforcement officers as a treating physician. Whether the district court erred in excluding all statements made by defendant to her medical providers based on physician-patient privilege. So this is a statement of preservation, just saying that we have preserved these issues, even though the other side brought them up, we do have the opportunity to appeal them. Now, this is a statement of the court's jurisdiction saying this is a pretrial appeal by the state from the June 3rd, 2024. Defendant Alexee Trevizo's motion to suppress entered by the Honorable Jane Schuler Gray. Defendant is charged with first-degree murder in violation of NMSA 1978. 32-1, that's the murder charge, or in the alternative, unintentional abuse of the child resulting in death in violation of NMSA 1978, 30-6-1D. Defendant is also charged with tampering with evidence and intermediate crime in violation of NMSA 1978, section 30-22-5B2. Because first-degree murder is a capital felony that carries a sentence of life imprisonment, this court has exclusive jurisdiction, meaning the Supreme Court, over the pretrial appeal. Basically, the end of that is just saying that this was filed when it is supposed to be filed. Now, statement of the case. This is where we get into all the facts. Relevant factual background. On January 27, 2023, defendant was admitted to Artesia General Hospital around midnight complaining of severe low back pain. She denied that she was pregnant and was administered medications. During her evaluation, defendant entered a hallway restroom alone and locked the door behind her. Defendant remained in the bathroom for an extended period and refused to open the door for staff who became increasingly concerned for her well-being. Hospital staff obtained a key from security to enter the restroom and told defendant they were entering, at which point defendant opened the door, exited the bathroom, and returned to her hospital room. When hospital staff entered the restroom, a large amount of blood was observed. As the custodian cleaned the bathroom, the custodian noted that the trash can was inordinately heavy. Upon further inspection, a newborn baby was found sealed in a trash bag under a new trash liner. Nurses began administering life-saving measures on the newborn baby. Nurses began administering life-saving measures on the baby boy. That is a concerning line. Just to pause right here, because no, they did not, unless they are saying that they opened the bag at some point, which they did. If that's considered a life-saving measure, fine, but no life-saving measures were performed on the baby as far as the testimony and the statements that I've seen in this case, so that might want to be corrected. But either way, so far, so good, other than that error right there. But he was already called in blue. Emergency department physician Dr. Heather Vasquez declared newborn baby dead at 2:28 a.m. on January 27, 2023. Rest in peace, baby Alex. Law enforcement was contacted. According to the state's pleadings, while law enforcement and defendant's mother were in the room with defendant, Dr. Vasquez entered the treatment room and calmly informed the defendant that we discovered a dead baby in the bathroom. Upon hearing the physician's statement, the defendant immediately replied without prompting, "I'm sorry, it came out of me. I didn't know what to do." The state submitted that defendant was not under arrest or restraint when she made that admission. The state also submitted that defendant's mother then proceeded to question defendant. Mother: "Alexee, I told you about this. I just asked you, baby, to tell me the truth." Defendant: "I was scared. It was not crying or nothing." Defendant's mother: "What did you do to it?" Physician: "Stop right there. Number one priority, guys. Number one priority is she just had a baby. We're going to airlift her to Lovelace. They want her to be there as soon as possible." Officers then explained that defendant was not free to leave and that one officer would always be in the room with her. However, they informed defendant that detectives would not speak with her until after she received necessary treatment. The state submitted that defendant's mother continued to ask questions to law enforcement officers and then asked defendant, "Where did you put the baby? Tell me the truth." The defendant proceeded to tell the mother that she put the baby in a bag. Officers demanded that defendant's mother stop asking questions. Defendant was transported to another facility for further medical care. A post-mortem exam determined that the baby had been born alive. At issue in this case is whether the district court erred in excluding all statements made by defendant to her medical providers based on physician-patient privilege, and whether the district court erred in excluding defendant statements made in the presence of the physician and law enforcement officers. Defendant's motion. On July 24th, 2023, defendant filed a motion entitled Exercise of Privilege, Motion to Suppress, Motion for Protective Order, and Pena v. Espinoza Procedure Determination. Defendant's motion. The factual crux of defendant's motion was premised on the argument that Artesia General Hospital, its personnel staff, and Dr. Voss all violated Rule 11504 and MRA, the Health Insurance Portability and Accessibility Act, HIPAA, and NMSA 1978-14-6 because defendant did not give consent to disclose her medical records, videotape, lab tests, lab reports, videos, personal identifies to the Artesia Police Department or the public. Regarding Miranda, defendant also argued that while in the hospital room, she was in detention. She posited that statements made in response to doctor and police questioning was in violation of her rights under Miranda. In total, defendant's motion requested that all her statements and medical records be suppressed and that the case warranted dismissal due to misconduct. State's response. The state filed the State of New Mexico's response to exercise of privilege, motion to suppress, motion for protection order, and Pena v. Espinoza Procedure Determination. State's response. The state argued that HIPAA does not preclude medical providers from disclosing information to law enforcement regarding a crime committed at the Artesia General Hospital under 45 CFR Section 164.512F. The state also pointed out that some of the information defendants sought to suppress was outside the scope of HIPAA or could be permissibly disclosed to law enforcement, citing to State versus Lucero, which we are going to take a look at. The state also argued that defendant had waived any privilege under Rule 11504 because she spoke to her physician in the presence of police officers and her mother. Regarding Miranda, the state argued that defendant was not in custody and that when the physician entered the room and advised that a dead baby was found in the bathroom, defendant immediately replied, "I'm sorry, it came out of me. I don't know what to do." The state also pointed out that law enforcement advised defendant that she was detained. They advised defendant's mother to stop questioning defendant. Finally, the state submitted that the demand for in-camera review under Pena v. Espinoza was premature. Okay, defendant's reply. In defendant's reply, she requested that the district court close the hearing on the motion and seal exhibits. So close it all down. Just so interesting to me. She also detailed some of her medical records and in essence argued that Artesia General Hospital failed to treat her adequately. Although defendant conceded that HIPAA does not have a suppression remedy, she went on to reiterate that she did not waive any privilege and that she was not informed of any such privilege. She continued that she should have been advised of her Miranda warnings because the doctor and police worked together to elicit statements from her. Obviously, that is phrased by the defense. You can, take how the doctor and police went into the room in your own, view. I don't really think they were thinking that they were going to get a confession necessarily. I think that they thought they were going to possibly become face-to-face with a suspect. I don't really think it's fair that the doctor and the police's intentions are being assumed when they have not been asked what their intentions were necessarily when they went in the room. That's maybe some testimony that would be good if we're assuming that they work together to elicit statements. There's actually no proof of that. All the doctor said was, I need to go tell her, before you guys go see her, I need to tell her that she's getting transferred and you can come with me, basically. And so even if she waited for them to come in there for her to talk about the baby to Alexee, that's still not with an attempt to elicit statements. That is possibly to not discuss a crime without the presence of a law enforcement officer. So just my 2 cents there. Now this moves on to the motion hearing, which you probably have all seen because it is here on YouTube. On August 22nd, 2023, the district court held a combined motion hearing covering 3 motions filed by defendant regarding defendant's motion to the state's response. Defendant stated that exhibits A through I were emailed to the district court and the district attorney. The exhibits included hospital records, put a pin in that for later, police reports, a video timeline created for the counsel by defendant. Defendant requested that exhibits be admitted for the hearing and that all exhibits be sealed. The district court stated that it had not received the exhibits, but it appears that the district court eventually received them during the hearing and was able to print some or all of the exhibits. The state objected only to the admission of the timeline on the basis that it was created by counsel for defendant and was work product. Defendant agreed that exhibit I was a proffer. The state did not object to sealing off the exhibits for purposes of the hearing. Now we're going to pause here and just read these footnotes. The first, which is back on page 6. In preparation for the statement of issues, the state requested the August 22nd, 2023 hearing. The recording is difficult to hear, and for unknown reasons, it appears that a courtroom attendee muted attorneys and or the district court at various times. The state has summarized the hearing to the best of its ability. Down here at the bottom, in preparation for the statement of issues, the state requested the exhibits admitted at the August 22nd, 2023 hearing. So basically everything that the defense brought to argue on this evidence, right? The district court advised that it did not have the exhibits. The district court appears to be working to obtain the exhibits. However, as of the date of this filing of the statement of issues, which is recently, the beginning of just this month, okay? So this was August of last year. The date of the filing of the statement of issues, the state did not receive the exhibits from the district court. So the state still hasn't seen what the defense has offered in their motion hearing and what they're arguing about. The state has received some exhibits in the form of unlabeled medical records from the defense, which we're gonna get into, I promise. Oh my gosh. Accordingly, the state respectfully reserves the right to amend this statement of issues upon receipt and review of all the exhibits submitted by defense at the hearing. So basically what they're saying is they offered up a bunch of BS that we didn't get to see. Now, this is... You know what, screw it. We're just going to go into the medical records here really quick. Everyone knows that we have been investigating the leaked medical records in this case, and that we knew that in some way, shape, or form that they were evidence. Why? Because they had been brought up in these hearings. Gary reads off the medical records in Alexee's first court appearance, right? Fresh out of jail. Their first court appearance, their preliminary hearing, they read off these medical records. Gary reads them off to Dr. Vasquez and cites the medical records we've all seen leaked here online. Now, fast forward to this motion hearing, Gary complains about them having been leaked. He said, it's something me and the state will have to look to eventually, right? He's bringing up this leak on his own medical records that he's entering as evidence. This is the defense's evidence. Now we know. We always knew they were evidence in this case. We thought that they were given to the defense possibly as the state's evidence here. But no, this is the defense's evidence. They brought this in, asked for everything to be sealed up. They have them leaked online. Pull up my screenshots that I have about that. Verified this message. This message was from 10th Woman, the person who's on defense witness list who leaked the medical records. And she says here in this message that I was able to obtain that was sent to a known TikToker that it was indeed Alexee's sister. Now that's interesting to me because they tried to make these whole little fake messages over here that she sent back and forth to herself. I verified that too. She made these whole fake messages right over here to try and make it look like it was the hospital who did it. So I don't know if their own attorney even realizes here what's going on behind the scenes, but it is hilarious. It is crazy that it's been the defense's evidence and they have it out here leaked up.
Nobody's gonna know. Nobody's gonna know. They're gonna know. How would they know?
On another note, on point 3 down here is something that is a bit concerning. So like I said, when it comes to the judge's decision that, is being argued about in this right now, because the judge basically said, it's all gone. You can't have none of your evidence except the hallway video and the autopsy, essentially, which I have always said, I still think you can get a verdict based off that. I think they can also, if I was them, get and authenticate the videos of Alexee cheerleading that are found easily online. And there's some very good videos that show that she was extremely pregnant looking, which would be extremely convincing to the jury. So it doesn't mean they've lost everything. There's other stuff they can possibly be looking for. But on the other note, the judge really seemed to have made a rash decision, in my opinion. Like, there is a lot of stuff you can read. There's actually a whole case decided by the Supreme Court that I found that we're going to reference that is 30-something pages just about the wording and how it has changed over the last 60 years or whatever in New Mexico when it comes to mandatory reporters and the privilege that comes with that. There is 30 pages of the Supreme Court pontificating and concluding about the proper language and how privilege should be applied. And I just don't think it adds up with what the district judge, Honorable Judge Schuler Grayhair or whatever, she, I think, in my opinion, just made a whole blanket statement with the evidence, which is the one thing we said she wouldn't do. We said, the judge would be smart enough to parse through the evidence and see what evidence is, admissible and what's not, and what would possibly be in furtherance of a crime and what's not. I really don't feel like that's what happened here. And that's without giving away too much of her reasoning, which I did find contradictory. Which I think this will touch on, so hopefully I won't have to say it myself. But anyways, we'll get into it. But this is a little point down here, because now that we know that the judge is definitely ruling, just a blanket ruling in favor of the defense, I have verified these documents in their sealed status many times over, because I have questioned, since I've seen things come out that are supposed to be sealed in this case. I'm always very cautious when I see a document, if I'm going to talk about it, that I verify if it's sealed or not. Now, I have verified that this number 3 down here is true, because the only document that was ever uploaded unsealed that was supposed to be sealed was the state's argument on the evidence in this case. Now, the defense's stuff has always been sealed up. It's always been sealed up and kept nice and clean and tidy. But the state, theirs gets put up without the seal. So that's a little concerning. It's like, come on, get it together for the state too. Just because the defendant has rights doesn't mean the state's job needs to be made even harder than proving their burden too. So it should be fair for both. The rest of the hearing consisted of argument of counsel. Although defendant agreed that there was no remedy under HIPAA, she posited that the doctor-patient privilege had been waived and that defendant's doctor-patient privilege applied from the first time she entered the hospital until she entered the bathroom and after she exited the bathroom. Defendant also argued that she was in custody while in the hospital room and that the doctor waited until police officers arrived to enter the defendant's hospital room. The state relied on its written responses to defendant's motion. The state responded that on the issue of Miranda, defendant was not in custody and that the statements made by defendant were blurted out with her mother in the room. The state emphasized that HIPAA was a statutory protection that was subject to a civil suit by defendant. The state argued that the statements made by hospital personnel records and the video was all improperly lumped together by defendant. The state emphasized that the defendant's mother was always present, and because a third party was present, no privilege was available. Further, the state argued that the video of the hallway was a public place in the hospital accessible to others without any patient-physician privilege. Critically, the state pointed out that the defendant did not offer any evidence that the doctor deliberately waited for law enforcement to arrive before entering defendant's hospital room. Personally, I don't think that even waiting for them matters. I think as long as Alexee was treated for the life-threatening stuff that was going on and was in the process of treatment, despite her not going in until the police got there extremely quickly, is not even a big deal. But again, critically, they did point out that it wasn't like the doctor was like, we're going to go in there together and pull this statement out of this chick and get her to confess. I think this is an interesting point, because when should the doctor confront her about this issue? Should the police officers only confront Alexee about the issue? Like, when and how is the acceptable, way that she should be talked to about this? Because obviously a dead baby was found. Is the doctor expected to go in there, give her a heads up, and be like, hey, yo, we found your dead baby, the cops are coming, and then what? They run out and leave? What if Alexee caused, what? I think the part that feels unfair to the defense is the fact that Alexee walks out of the bathroom, thinks she's all good, doctor's treating her, thinking she's having a miscarriage, the baby's found, and a bunch of stuff happens without Alexee knowing that stuff is happening. Right? Now, what if they didn't even think it was Alexee? Let's do a thought experiment, because this is literally what the Supreme Court is going to sit there and do. And they think and they study and they read and they analyze. I just love the Supreme Court. I love appeals. It's fascinating, and they are some of the highest minds in our society, in my opinion. So let's do this thought experiment. We have 3 women of childbearing age. 2 came back with positive pregnancy tests, but we did find a dead baby in the trash. Now, the person who was in the bathroom when we found the dead baby in the trash. So if police are informed of information like that, how is it that they would get into the patient's rooms? And how would we assess that legally? Because if there was an option between people, would it be the woman who left the bloody footprint going back to her room? I think they'd go into that room, right? So whether or not the doctor actually physically pointed out which room and which person they thought it was, I don't think even matters or plays a part, because as soon as they found a dead baby, I think that the bloody footprint would lead you back to Alexee's room. That's just my opinion, and obviously a metaphor, because the bloody footprint was already mopped up. But you get what I'm saying, is that if the bloody footprint fits, then it's it. Now, these post-hearing pleadings are what was sealed, and the state's is the one that was uploaded unsealed, essentially. Both the state and defense submitted findings of fact and conclusions of law. In defendant's sealed findings of fact and conclusions of law filed on August 30th, 2023. Woo, we get as close as we can to read it here. Defense requested conclusory factual findings, including that the ER doctor refused to speak with defendant until the police arrived. The defendant was not free to leave and was detained. Defendant conceded that her mother was in the room with defendant during her time in the hospital, but that her mother's presence in the room did not waive any physician-patient privilege. Regarding Miranda, defendant summarily concluded that when the doctor informed defendant regarding the baby found, such was a custodial interrogation requiring suppression of all of defendant's statements. I don't see it as a custodial interrogation whatsoever, but that is just me. In the state's sealed findings of fact and conclusions of law filed on September 12, 2023, the state, citing to the body camera footage, submitted that Dr. Vasquez entered the treatment room and calmly informed the defendant that, quote, we discovered a dead baby in the bathroom, end quote. Upon hearing the physician's statement, the defendant immediately replied without prompting, I'm sorry, it came out of me. I didn't know what to do. The state submitted that defendant was not under arrest or restraint when she made that admission, citing to Rhode Island versus Innis. The state submitted that the exchange between defendant and the physician did not rise to the level of a police interrogation. The state also submitted that Rule 11504 and HIPAA allowed for hospital staff to communicate with law enforcement regarding the commission of a crime, and that the defendant was aware of the hospital's obligation when she signed a patient acknowledgement of rights form. Further, citing to State versus Lucero, the state argued that defendant waived any privilege when she made statements in the presence of her mother and law enforcement officer. Now that's interesting because, like I said, we're going to talk about State versus Lucero, and when they say here in the presence of mother and law enforcement officers, I believe that is the crux of the argument of State versus Lucero and why it is a losing case to cite for the defense. But again, that's just my opinion because obviously the judge didn't rule in our favor. I don't know what the judge is thinking, but maybe she ain't. I don't know. Just kidding. That's just my opinion. But anyways, the important part is in the presence of law enforcement officers. Okay. So on May 13, 2024, the district court issued its findings of facts and conclusions of law of the court, which did not cite any case law. Legal burn. legal burn right there. Did not cite any case. This is just such a legal burn because she really didn't cite any case law, any reasons for her finding. Now, I said that there is a very big case from very recently that the judge could have found and went through, and that I think that the Supreme Court is going to be like, hello, we literally just went in depth on this 32 pages about the history of this actual subject in our state, but no big deal. Thanks for digging in. Not saying she did or didn't. This is my legal ramble because boom, legal burn. She didn't cite any case law. The judge was just like, here you go, defense. You get all of your stuff suppressed. Like, not even a big deal. Not even thinking about it. I'm the judge, main character energy. I do what I want. Essentially, the district court determined that Dr. Vasquez was acting as a police agent the moment she walked into defendant's room. Yet at the hearing, the district court was not presented with testimony to suggest that Dr. Vasquez planned her entry into defendant's room, that her only purpose was to elicit incriminating statements from defendant, or that she acted in concert with law enforcement agents. Boom. Sorry to take a pause in the middle of it, but boom, I agree. It's like we need the testimony of the doctor saying, oh no, I wanted her to confess to the police. No, she's like, no, I'm in here to tell you that you need to get on this helicopter and go to a better hospital because I don't know what's going on and what actually happened to you now, and we don't have the equipment to deal with it. And you could die if you have even a little bit of placenta left in you, I guess. So you gotta go. And that was her main concern. If we have testimony from Dr. Vasquez as to such, then I think that would be extremely productive. But maybe that's just me. It seems like the state also thinks so because I just heavily agree with that. In fact, the medical records that defendant provided to the state, as noted in footnote 2, indicate that Dr. Vasquez performed a pelvic exam on defendant prior to learning that a dead infant had been found in the bathroom trash can and prior to police being called. The district court found that when defendant stated, I'm sorry, it came out of me, I didn't know what to do, defendant was detained and that Dr. Vasquez and or law enforcement were required to give defendant Miranda warnings, which is not the case. The court also concluded that Dr. Vasquez failed to honor and invoke the physician-patient privilege on defendant's behalf. No, my patient may have just murdered a baby possibly, but I am not assisting law enforcement officers in this investigation. That's my patient and her privilege to put a baby in a bag on my watch. That's crazy to me. To invoke patient privilege on defendant's behalf, but instead acted as an agent of law enforcement. What a crazy finding. It's like, that's not what the law says in New Mexico at all. It does not say that at all. Not in any of the case, not in any of the precedent. No precedent says, oh, hey, doctors turn into police officers when they witness a crime, and getting any information is now is now subject to Miranda. That's crazy. That's just crazy. The court also, now this is also concerning as F. Like, the court also raised whether defendant was under the influence of a narcotic drug when she made the statement, an argument not raised in the hearing on defendant's motion. Essentially, the judge was like, and you know what? I'll raise you one. Alexee was high on drugs when she did it. Yep, so innocent over here. Yep, she was high on that morphine. Wow. I'm not saying the judge is biased. I'm just saying, what was she looking at? What did the defense give the judge? Because, like, are you seeing the same shit we're seeing? Because I don't know. Am I crazy over here? What is she thinking? The district court's order granting defendant Alexee Trevizo's motion to suppress followed on June 3rd, 2024. The order granted suppression of all statements made by defendant to her medical providers on the basis that doctor-patient privilege applied, and granted suppression of all statements made by defendant in response to her physician in the presence of police officers. The court did not exclude the medical records or the hospital video showing defendant entering and leaving the bathroom. There are no prior related appeals. State respectfully requests the court to place this case on its general calendar and reverse the district court. And basically the rest is just everyone who got served and the signatures and everything. So I will spare you those details. Now, here's one thing that we are learning. The medical records are going to be used as evidence, and they are allowed in, according to the judge at this time, because it says here they did not exclude the medical records or the hospital video showing defendant entering and leaving the bathroom, which I think is the nail in the coffin for the case other than the autopsy. So good for us on that. But it is interesting that the defense is going to enter a little bit of maybe just the medical record. Now, what I find interesting is without any of this evidence, there is also no defense. Just let that sink in. Without being able to poke holes in the surrounding part of the story, if all they visually see, and other than hearing whatever witnesses Gary is going to parade around, literally a team of jokers, okay, that in my opinion, but also like you guys saw my video on Chris Sperry. We all know this is not a serious, like hard-hitting witness team that's coming together for her. It is just a bunch of jokers, right? And so that's all you have. And then you have the state having an ominous ass video of Alexee going into and out of the bathroom and the autopsy showing the baby was dead. And it's just my opinion, but I think that we still have a great case no matter what the Supreme Court says about the medical evidence. One of the reasons why is even though they're not supposed to, juries can fill the holes in time in their mind with what they think happened. So, like we said, we will be talking about the state of Mexico versus Lucero. This is a very interesting case. Here is the quick rundown. We have talked about this case way earlier on this channel because I thought it was a losing argument for the defense. I still think it is, and I don't think we've been proven wrong at all because clearly you just heard that the judge didn't cite any case law. So I'm not even sure if she went back and read Lucero here, but who knows? So I'll just give you a quick rundown of what happened in this case and why the evidence was thrown out. Lucero is a driver driving under the influence who flips their car. A police officer and EMTs are arriving on the scene. The police officer smells alcohol on Lucero's breath. Lucero is taken into the ambulance away from the police officer. Lucero does not know that the police officer is following them towards the ambulance. The police officer never crosses in the line of vision of Lucero and enters the ambulance from behind, unknown to Lucero, when Lucero is answering questions to an EMT about what they have had to imbibe in that night. Now, you would think that one person, even though DUIs are serious and they shouldn't be taken lightly, rights are also a thing. It is important for someone who partook in substances to be able to be honest with an EMT person. It is also up to the police officer to gather information correctly. The officer can maybe be implied as someone who was laying in wait to hear this information from Lucero, because the officer waited behind Lucero in the ambulance and let Lucero talk with the EMT for a while before speaking up and saying, "So what have you had to drink tonight?" Lucero whips their head towards the police officer and says, basically like, "Hey, I didn't know you were here." And they shut the F up and basically stop talking in front of the officer. Now, that is someone who knew their rights, and had they known that the police officer was there, they would not have been speaking, and they thought they were safe to tell someone who might possibly be administering medication to them the truth about the matter. Okay? That is very, very important. It's a very important difference in this case. In this case with Alexee, the police officers walk in plain view into what is considered by the district court judge in her findings, the privileged room that Alexee's in. Well, she sees the officers when she makes her statement. She's not asked anything by the police officers. She's actually not asked anything at all. So I do think that the Supreme Court is going to maybe see this a little different than the judge, because this is the case that the defense is citing as two statements made in front of police and medical professionals being thrown out. But it has a very different background than the Alexee Trevizo case. The facts are different. Now, this is from a very important case that the Supreme Court took up, State versus Strouch, New Mexico case, talking about privilege and how it's applicable due to abuse on a child who is privileged. It's literally 30 pages about the history of how this verbiage has changed in the law throughout New Mexico, throughout time, why they think it changed like that, why it doesn't matter that certain people, it's so fascinating of a document. If you're a legal nerd, go read New Mexico versus Strouch, and it is going to blow your mind when it comes to the interesting aspects of privilege. Now, a district court, kind of like what happened in Alexee's case, erred in their decision, according to the Supreme Court, for this case, because the district court basically said that they had interpreted official capacity for a privileged communication with a healthcare or mental health provider to mean that that was a governmental capacity, okay? Meaning that they had to be hired by the government to be treating someone for it to be waivable privilege. Not anyone in private practice could ever have privilege waived. Now, this was an interesting case because it was about an abused child, and there were mandatory reporting laws that swept the nation in the 1960s, basically making every state have mandatory reporters. Now, this case touches on two very interesting things when it comes to what's being argued in the Alexee Trevizo case. Number one, official capacity, because the district court judge is essentially giving an official capacity to the doctor when there is just no precedent for that in the law, and then also completely negating the long history of mandatory reporting when possible child abuse has happened. What the judge in this case decided is basically, in my opinion, completely backwards from the precedent. Now, luckily for us in New Mexico, the Supreme Court decides issues of privilege de novo, which means they do not care about what the district court judge said. Any issues of privilege are decided de novo, anew. They will decide them on their grounds, on what they find and find to be true and correct and accurate according to the facts and the situation. Now let's read what's here on the screen, because this is just a little excerpt from part of the Supreme Court's decision in New Mexico versus Judge, talking about all this privilege. Now, the basic privilege applicable to communications with physical and mental health professionals provides that a patient has privilege to refuse to disclose or prevent any other person from disclosing a confidential communication made for the purpose of diagnosis or treatment of the patient's physical, mental, or emotional condition. Rule 11504B. Rule 11504, what we've been arguing over in this case. The privilege generally seeks to ensure that a patient can communicate fully with a mental health professional without the risk that the information will be used against the patient in a court proceeding. Recognizing as well that such uninhibited communication serves the public interest by facilitating the administration of appropriate treatment. Pause. Was Alexee being given the appropriate treatment? Not according to the defense. According to the defense's own arguments, they may have given us a loophole out of this whole privilege thing, because they're saying she wasn't getting the appropriate treatments. Now, her communication was probably to further her not have the appropriate treatments. So that is going to be an interesting aspect for the Supreme Court to look at. Basically, what I'm saying is, by her saying I'm a virgin and all the statements she allegedly made to these healthcare staffs, wasn't that her automatically undermining her own privilege by not seeking the appropriate treatment? I don't know, but it is possible. Just the legal argument that I'm seeing here. Now, number two, if we go back up here where it says the privilege generally seeks to ensure that a patient can communicate fully with the mental health professional without the risk of the information being used against them. Now, was Alexee communicating fully with her medical provider at that point? I think that is something that the jury will get to decide, and I think that the evidence should be in. And I think that possibly the Supreme Court will see it the same way. Down here, it continues. Privileges often have limits, particularly when there are conflicting interests that may outweigh the interests of confidentiality. See Rule 11503D. Now, this is interesting because the Supreme Court is referencing attorney-client privilege and the limitations that can be placed on it when they are discussing a different privilege, which is the privileged communications with a healthcare provider. So let's take a look at what this 11503D is. Exceptions: there is no privilege under this rule. Furtherance of a crime or fraud. So basically what this exception to attorney-client privilege is except in the furtherance of crime or fraud. Now, is it possible that the Supreme Court will also conflate Alexee's statements made to the healthcare professionals as in furtherance of crime, therefore negating the privilege? Okay, now we have one more part that says, we have repeatedly cautioned that despite the beguiling simplicity of parsing the words on the face of the statute, we must take care to avoid adoption of a construction that would render the statute's application absurd or unreasonable, or lead to injustice or contradiction. So I take that to read as, if the interpretation is absurd or unreasonable or would lead to injustice or a contradiction, then we essentially would waive the privilege. So I see this looking up now that the greater minds of the Supreme Court are going to be the ones looking at it. Now, I have found out a lot due to this filing. Number one, that the medical records that have likely been leaked online were a copy that were straight from the defense. So I think that also helps us prove and know, at least in my opinion, exactly where all these leaks have been coming from. I think we can finally put to bed once and for all that indeed we know that the defense witness has been getting these documents from someone in the umbrella of the defense team this whole time. I do genuinely hope that no more weird implications, such as it being someone from the hospital having put these records out, are perpetrated online, because again, we now know that that is just blatantly false. I have gotten proof that the messages that we received and saw that were between quote unquote the source and the leaker of the medical records in this case, that very heavily implied that the person speaking with the leaker was from the hospital, were actually the leaker messaging themselves and making those messages. So those messages have been proven completely false. The one message that hasn't been proven completely false is this message and admission from the leaker right here, talking about how it was Alexee's sister who gave her these records. It was only after that admission came out and a little bit of hubbub happened around it that they started saying stuff like they're going to need this to get the medical records thrown out. It was a HIPAA entity. There was someone from the hospital making these fake messages. Very interesting, very interesting. As of right now, all we know is that the next time the parties will meet in this case is for a motion hearing, which is just days before when trial was supposed to start here in this next month. So it appears that we're going to be waiting on the Supreme Court, and we will probably get a very well-reasoned and very insightful decision back from them, and then trial will proceed as normal. It likely will not be in August, though. That is just, pretty guaranteed. I do have hope that the Supreme Court will make the right decision, and I am utterly shocked at the judge's decision. I love the legal mic drop that the state put in there saying that the judge did not even cite any case law. So who knows how deep and hard the judge actually looked into this. In my opinion, she sneezed and accidentally hit some stuff on her keyboard, and that is the decision we got. But hey, that's just my opinion. I'm just throwing a little bit of shade her way, because what the hell did I just read? I mean, it's supposed to be sealed, so I wasn't supposed to read it. But I mean, you have the defense making all these documents public, and nothing's happening due to that either. And so, not quite sure what the judge is even doing. She did file an emergency motion for an emergency hearing to be sequestered, but then nothing happened. Right now, we haven't heard nothing on that either. So what's going on? All I know is I will keep you updated as soon as we hear from the Supreme Court. Now, there have been other motions and small filings in this case. Gary Mitchell trying to get more medical information, subpoena medical records from different places. Both of his subpoenas have had motions to quash filed, so I do not know what he has been able to obtain when it comes to him trying to get some other weird medical information, which is odd because he's already offered these medical records as evidence. So what else is he trying to get? Now we know those are his medical records, so very, very interesting. We're going to have to see what they're trying to do with this defense. One more other interesting piece of information, there is a new attorney on Alexee's team. Her name is Amber Feyerberg. We will go over what I think about her being added and some of her history regarding criminalized pregnancies and everything like that. And if I think that that is a very wise defense to move forward with, basically victimizing Alexee, I don't know. We'll have to discuss it together in the next video because I know this one has been long and very dense with a lot of legal information. I've seen a lot of people doubting this case, saying it's over, saying that nothing, that Alexee's not going to be found guilty of anything, which As of right now, she is innocent until proven guilty, but do I think that the state doesn't have a chance with this? No way. I think that they have such a strong case, and I think that we're going to get such an interesting legal document back from the Supreme Court. Because, I mean, one last thought experiment before we go. If you were just at like a regular corner store or somewhere with a single stall bathroom, let's say, and the door is locked, and we're doing this thought experiment not in a hospital. Now, what would Alexee's defense be if she was, like I said, somewhere else in public, in somewhere with a single stall bathroom? She locks herself in the bathroom for 20 minutes. For some reason, a lot of people have to go to the bathroom in those 20 minutes, and a line starts forming, and people are like, hey, you good? She's like, yeah. They're like, hey, can you come out of here? Eventually, the staff of the place is like, hey, we're coming with a key. We got to get in there. We're concerned for you. And she pops on out. Now she walks out and leaves a bloody footprint, and there's blood all over the ground. At some point, whoever pulls the short stick has to go in and clean the bathroom with all the blood in it. And at some point, they find a baby in the trash. They call the police. They talk about anything and everything that had been said by the witness to police that night. Police then go find her at her, movie seat or wherever she might be out in public. What would the defense be then? Because the things we know that we can apply to this thought experiment are she locked herself in the bathroom and didn't tell nobody after she came out. The baby just had to be found. So if that happened anywhere other than hospital, what would be the legal framework for the evidence? What would be admissible due to that situation? It would definitely not be what the judge decided, I'll tell you that. And so if the only difference is that this crime was committed in a hospital rather than in a movie theater or a corner store or a gas station, then I really do not think that that's the get out of jail free card that Alexee and the defense might think it's going to be. They don't have solid legal defenses to this. Like I said, State versus Lucero clearly had a different situation in which those statements were suppressed. Not the same situation at all. So I think they're going on a hope and a prayer right now, as far as now the people who really think about legal implications and the evidence are getting to see this. The judge did not seem to, she was either, at least in my opinion, biased as to the situation or did not think this all the way through. That's just how I see it. I think that the Supreme Court is going to come back with an extremely different perspective as far as the statements made, because they seem to conflate parts of the exceptions to attorney-client privilege in with the statements that are privileged with hospital staff and medical professionals, etc. So if those statements are made in furtherance of a crime, those aren't privileged. If a doctor gives one of his patients a bunch of medications and he fills up a bunch of syringes for him to go kill his wife, but he was always there under the guise of him having medical procedures done when he was gathering these things from a doctor to perpetrate a murder, is that privileged information or is that in furtherance of a crime? And how would the Supreme Court see that evidence, right? And so I do think that there is a lot to be worried about if you're the defense when it comes to the Supreme Court looking at this, because I have spent hours and hours the last couple of days trying to look up every relevant case, every precedent that I can find as far as privilege goes in this state. And as far as it looks right now, the evidence of intent to murder and the baby being found in a bag is likely going to outweigh the privilege, in my opinion. Again, just my opinion, but we'll have to see what the Supreme Court decides when they do decide. And a side note, now that we know all about these medical records and who they really came from, what side they're on, and isn't it just so weird that they complained about these medical records being leaked when it was their evidence and they're the ones who obtained it, entered it, never have given it to the state, and we're like, hey, this got leaked online. Interesting if that falls in line with the whole defense of victimizing Alexee, which we'll talk about in the next video with the new attorney that's been added, and how I think her presence adds to a defense of just straight up she's a victim, which is not a defense, in my opinion, that you want to go with, because on about day 2 or 3 of hearing that, I think the jury is going to be over it. Again, that's just my opinion, but thank you so much if you made it this far in this video. If you have any comments, questions, or concerns, please leave them down below and I'll get back to you as soon as possible, and I do genuinely enjoy the conversation. If you're interested in following cases like the Alexee Trevizo case to trial, please subscribe, as I'll be covering it all along the way with a legal focus. It's your girl Friday. I'll see you in the next video. Okay, bye.